this issue, and they did not.
They don't have to measure it. That's the burden of proof it's on the state.
I understand that, but it wasn't raised. Is our
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant, or what are you claiming you said?
I asked him if there was. I believe I asked. I know I asked him about it. The question I asked, I think I asked him something along the lines of, did you believe there was any violation for the barrel length of the gun?
That would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28 or is not in compliance with the two sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with...
You have to show one of the three. You have to show one of the three. No. What am I saying?
No, we have to show...
You have to show any of the three which the defense has put in issue.
So
the defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And, Judge, if we can unpack this for a minute. So the exception says it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay? That's one way you can be convicted. And it says, or are in violation of Wisconsin statute, I think it's 29 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17.
No.
Okay? So I've conceded, because he has to be in violation of both 29304 and 29593. I concede he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second exception as well. I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I ruled as I did because the motion to dismiss attacks the complaint. And the complaint was adequately pled under the law. That was not an endorsement of the state's position on the case. And to use a trite expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires. And do you dispute the fact that you need to prove that the defendant was under 18 at the time of the incident? You don't. That's not in dispute.
That he's under 18, yes.
And that the barrel length was less than that allowed by law, or was not within the range permitted by law.
We don't have to prove that.
You don't have to prove that.
But it's or. I mean, there's no real. Our argument is that they did not raise it. I don't think it's really a disputed fact, but we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5.
Go ahead. I'm sorry.
They've conceded the 29.593 portion. He did not have a hunting certificate. So then we go to 29304, and if it is allowed that simply being 17, he is in compliance with that, it swallows the whole statute, and the statute makes no sense. So if the statute
makes no sense, you're out of luck.
Well, if the statute is valid, it's clear as day that it says a person under 18 years of age.
I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law, 2A is quite clear.
It is.
Sure. Any person under 18 years of age who possesses or goes
Well,
armed
that's
with
not
a
the whole
dangerous weapon.
statute. That's not the whole statute.
Our position is that he is not in compliance with 29.304 and 29.593. And I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
Under 16 cannot, and that is what 29.304 is addressing. This statute is addressing hunting.
No, the basic law is that the rubric is not part of the statute.
The rubric?
The title.
The title is possession of a dangerous weapon by a person under 18.
It's not part of the statute. No, I learned it in an
That's what
earlier
the
time when we called it the rubric.
That's what the statute says, though. That's what it says in 2A. And the state's position is that he is not in compliance with those two, and that they have not raised the short barrel shotgun issue.
The what?
The short barrel shotgun issue, but they don't really have to because they can try to raise the other part, but they have not done that either.
By his age, it's raised. On the second part. It's raised.
Yeah, that's true.
So that's it. And I just want to make sure I've been losing this argument. It's not, Judge, there are hunting portions of that statute, and there are just simple possession portions of that statute, of 29.304. I am not focusing, and I'm asking that it doesn't apply, the hunting part. If you read the Legislative Bureau, what it says is, if you're 16 or 17, there is an exception for you to possess a firearm.
It does say that.
Semicolon, done. It has nothing to do with hunting. Nothing.
My inclination now, once again, I'll tell you what I'm inclined to do, is to inform the jury let's see.
Judge, may I respond to Attorney Sharofsky?
Yes.
Legislative history only becomes an issue when there's ambiguity. There is no ambiguity in 2A. It is very clear that 18-year-olds are not to possess dangerous weapons. So you interpret the statute in a way that makes sense. And the way that it makes sense is that simply because he's 17 does not automatically negate 2A.
Well, I raised it earlier in the case, and it hasn't enjoyed a lot of discussion, and maybe I'm off the wall. I don't think so. The penal laws are construed strictly. Vague laws are. Who is that emperor from way back in history who posted the laws on pillars so high that the people couldn't read them? And that's been used by lawyers and judges for centuries about the requirement that people be given knowledge of what the law provides. And the basic law, and it's chipped away a lot of times with the appellate court decisions that are made on the subject in efforts to preserve the statutes, because some of them are quite messy. And that's not a criticism, that's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this, and now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for I'd hate to count the hours that I've put into it. I'm still trying to figure out what it says, what is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to acquaint herself with what this law says?
Judge, there's testimony that the defendant, Mr. Black's stepfather, the defendant's mother, all knew he could not legally possess this gun. That's why he was kept up here. That's why Mr. Black bought it. This 2A is very clear.
For interpreting a penal statute?
I'm sorry?
Is that the standard by which the judges interpret a penal statute?
You just said it should be clear to normal everyday people, and it was clear to these normal everyday people. Because it's very clear that under 18 cannot possess a dangerous weapon.
They don't know the law. And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
Obviously, we're responding to your...
Well, but the point is, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, don't use your cell phone while crossing the street. Now, if they adopt a law that says that, and people are, not, as I told the jury before, ignorance of the criminal law is not an excuse, so people are charged to know that, unless it's written on the top of a pillar so people can't see. People, if they're given legal notice, that's why they publish them in the newspaper. If people are given legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather or father or whatever it was, or the defendant's father or whatever. Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right. I can tell you I've put many hours into it, so have you. And how are ordinary people not supposed to know what they should be afraid might be against the law? How are ordinary people supposed to know what's against the law?
Because 2A is very clear.
Wish it were to me. I'm going to my intention is to instruct on what he's submitted, without page numbers, I might add. Looks like the third page that starts statutory definition of crime, and down to where it says or. So it'll be exception, the state must prove, etc. Then number 1, the defendant was under 18. Number 2, and that the dangerous weapon was either a rifle, etc. And you can search the evidence to find out if you can prove beyond a reasonable doubt that that's true, so that it can go to the jury. All right, now, is that it?
The state requested the 805, 810, and 815, as well as 9.
Any dispute as to those?
805, no.
Okay.
810 and 815 are the retreat and provocation instructions, so yes.
Okay, go ahead.
Well, I guess I would ask this first, Judge. As it relates to 815, which is the provocation instruction, is the state saying the presence of Mr. Rittenhouse there is in and of itself provocation?
No, we are saying that in the incident of Mr. Rosenbaum, he provoked it by raising his rifle and pointing it at individuals So that is why Mr. Rosenbaum then